You've seen it in 1,000 movies, right? The lawyer on the attack, cornering a witness, just hammering them with questions until they finally crack. But what if I told you the real art of cross-examination isn't about breaking a witness down? What if it's actually about telling a story? Well, let's get into it.
This quote from the legendary trial lawyer Jerry Spence, "This is everything." He's basically saying that a great cross-examination isn't an interrogation, it's a narrative tool. The lawyer isn't really asking questions, they're making statements, telling their side of the story, and just getting the witness to agree, one yes at a time.
So here's our game plan. We're going to start with the why, the constitutional right behind all of this. Then we'll look at the old-school aggressive style, and finally, we'll dive into a couple of modern techniques that are totally changing how the game is played inside the courtroom.
First things first, why do we even have cross-examination? I mean, is it just for the drama we see on TV? Absolutely not. It's a fundamental right, and it is crucial to our entire system of justice.
This right here, the confrontation clause, trial lawyer Eric J. Davis calls it the bedrock of the whole system, and for good reason. It means you get to face your accusers in the open. It means testimony can't be secret. It's our main line of defense against being railroaded by accusations made in the shadows.
And this is not some new idea. The principle of facing your accuser goes all the way back to Roman times. It was baked into English common law, and the founders thought it was so important they put it right there in the Constitution. It's a right that we've been protecting and even expanding for centuries.
Okay, so just because it's a right doesn't mean it's easy. In fact, mastering cross-examination is one of the hardest things a lawyer can do. Let's take a look at what it really takes.
You know, according to insights from folks like trial lawyer Eric J. Davis and socio-trial expert Professor Brandon Blankenship, almost nobody is just naturally brilliant at this. For most, it's a craft that's built on this really tough mix of intense training, relentless preparation, a spark of creativity, and just years of being in the trenches. It's a true blend of art and science.
All right, so let's talk about the style that everybody recognizes. The classic, aggressive, in-your-face attack. This is what's known as the destructive cross-examination.
The goal here is pretty simple: destroy the witness's credibility in front of the jury. The lawyer is in total control, trying to expose lies, inconsistencies, or biases to make the other side's case look weaker. And one of the main tools for this is something called impeachment.
Think of it like a classic three-punch combo. First, you get the witness to recommit to what they just said. Second, you build up a different statement they made before, maybe under oath, when their memory was fresher. And third, bam, you confront them with the contradiction. It's a super powerful way to show a jury, hey, you can't trust this person.
But that full-on attack isn't always the best move. Some of the most brilliant lawyers today are taking a totally different route, one that relies more on psychology than on brute force.
The key to the soft cross is empathy and being hyper-aware of how the jury sees you. You see, as Professor Brandon Blankenship points out, jurors today are pretty skeptical of lawyers who just look like bullies. And this is especially true in what you might call socio-trials, where the emotional backstory is everything. The soft cross isn't about attacking the witness, it's about gently revealing why they might be saying what they're saying. And this example just lays it out perfectly. The traditional attack goes straight for the jugular, focusing on the punishment. It's logical, but it can feel cold and aggressive. The soft cross, a technique that both Eric J. Davis and Professor Blankenship champion, focuses on the emotional loss, not being able to see your own kids. This doesn't just suggest a motive, it helps the jury feel the witness's desperation, making their potential bias way more powerful and human. And this brings us to the ultimate evolution of this skill, where cross-examination stops being a fight altogether and becomes a story, where the lawyer is the storyteller and the opposing witness is just there to prove the story is true.
The rules for this are so simple, it's kinda brilliant. You talk like a normal person, not a lawyer. You just make short, factual statements. The witness's only job is to agree with you. And with every single yes, your story gets stronger in the jury's mind. And you stop being an interrogator and start being a guide, just walking them through what happened.
So how do you even prepare for this? Well, as Eric Davis explains, you literally just write out the story you want the jury to hear, just like a simple paragraph. Then you chop that paragraph up, sentence by sentence, and turn each little fact into a statement for the witness to confirm. Let's see how it works. So the lawyer starts with a simple, undeniable fact. It's the first brick. You can't argue with it.
Another brick in the wall.
You can feel the momentum building, right? It's a rhythm of agreement. The jury's just listening to a story now, not a back-and-forth fight.
Okay, and this is where it gets really clever. Do you see what's happening? With every yes, the witness is accidentally transferring their credibility to the lawyer. The witness is basically telling the jury, yeah, this lawyer knows what they're talking about.
And just like that, it's done. A whole story, with tons of specific, verified facts, has been told directly to the jury. And the witness? They never had a chance to argue or explain anything. Their only job was to say yes, giving the lawyer complete control over the narrative.
So, what's the big takeaway here? It's that the best trial lawyers are moving on from just trying to destroy a witness. They get that juries today don't always respond to aggression. They're using smarter tools, like the soft cross and storytelling, to connect with the jury and build a narrative that is just way more powerful.
Which, of course, leaves us with one last pretty fascinating question. When persuasion becomes this powerful, when the goal is to tell the most compelling story, does the best story always lead to the right verdict? Does it always reveal the actual truth? Definitely something to think about.